James, you're on mute if you're trying to talk to us.
You'll be live.
Very good. So good morning. As indicated on our agenda, our first order of business is to enter a closed session. The purpose of the session is to hear and discuss legal advice from the Office of the Attorney General concerning compliance with provisions of the sports wagering law pursuant to General Provisions Article Section 3305B7. I believe it's reasonable to allocate 1 hour for such discussion, and therefore I want to advise the public that we expect to reconvene in open session at 10 o'clock today Eastern Time. If it looks like the closed session will extend beyond an hour, then staff will endeavor to advise the public of the updated time at which we expect to reconvene in open session. So now I request a motion to adjourn to closed session to hear and discuss legal advice.
So moved.
Second.
Any discussion? All in favor?
Aye.
Aye.
Any opposed? None. So with that, would you please proceed to put us in closed session? So I guess we join room 1. James, I'm looking to your guidance as to how to proceed.
Just making sure we have everyone. Yes, we have everyone.
Very good. Thank you. Good morning again. We're now reconvening SWORC's August 17th meeting in open session. It's noteworthy that it has been now a year since our first public meeting. When I accepted this appointment, I was told that SWORC's mission would be legally challenging and complex. And so it has been. And there's been much to learn about the nature of the new sports wagering industry in Maryland, in contrast to some other regulated businesses where public policymakers have endeavored to enable diverse participation. I just want to thank all the commissioners and our advisors for their continued counsel and perseverance. SWORC has now awarded sports wagering facility licenses to 9 of the 17 facilities designated in Maryland sports wagering law. Today, we will act on 2 more applications. When SWORC last met on July 13th, we approved SWORC's proposed regulations and drafts of applications for the competitive sports wagering licenses. That is both the mobile sports wagering licenses and the additional Class B fixed site sports wagering facility licenses. So following our last meeting, SWORC's proposed regulations and draft applications were posted on SWORC's website so that prospective applicants could familiarize themselves with the type of information that SWORC will be seeking. I've been told there have been some questions concerning the 5% disadvantaged ownership requirement included in the regulations. As a reminder, the regulations require every applicant, whether for a mobile license or a Class B facility license, to demonstrate that at least 5% of the direct or indirect ownership of the applicant is by individuals with a personal net worth less than $1.8 million. And in response to those questions, we've posted on the SWORC.org website an FAQ concerning this ownership requirement, which we hope is helpful to all applicants. Maryland Lottery and Gaming sports wagering applications were published almost a year ago. And then on June 16th, 2022, Maryland Lottery and Gaming opened the e-licensing portal so that prospective applicants for the competitive licenses could begin preparing and submitting information for background investigations. There are 2 items that must now be completed before SWORC's application process can proceed. First, Maryland Legislature's Joint Committee on Administrative, Executive, and Legislative Review, or AELR, must vote to approve SWORC's emergency adoption of its regulations. And we hope this vote will take place in the coming days and that our approval will be forthcoming. With respect to the, on July 22nd, we submitted our proposed regulations into the Maryland electronic filing system as regulations to be adopted by SWORC on both an emergency and a non-emergency basis. With respect to the emergency basis regulations, AELR has acknowledged receipt of our action, but has not rendered a decision. With respect to the submission of the regulations for adoption on a non-emergency basis, staff believes that the proposed regulations for adoption will be published in the August 26th edition of the Maryland Register. Publication of the regulations in the Maryland Register begins a 30-day comment period for these regulations. If substantive comments result in changes in the regulations, then release of our applications could be delayed. Second of the items to be completed, SWORC must receive the sports wagering industry analysis, and the Office of Attorney General must conduct the necessary legal review of the analysis. As to this second item, Recall that SWORK directed that this industry analysis be procured at our September 2021 meeting. Certainly, it has taken much longer to receive this analysis than any of us expected. SWORK is hopeful that these two items can be completed promptly and that the application process for the competitive sports wagering licenses can commence soon. Later in this meeting, SWORK will discuss and establish a window of time, say 45 to 60 days, within which applicants must complete and submit their applications to SWORK. After the applications are submitted to us, then there will be a period for SWORK to review the applications, and after award, a period for testing of internal controls. We'll further discuss the timeline later in this meeting. So with that, we'll proceed down the agenda to staff presentations and action on two license applications. Jim and
Okay, Mr. Chair, if we can now move to the approval of today's agenda.
oh yes. Do I have a motion for approval of the agenda as it was submitted in advance of the meeting?
So approved.
Second.
Any discussion? All in favor, say aye.
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 Any objections? Agenda's approved.
Great. At this time, commissioners, we will be acknowledging receipt of the application packets for the recently qualified applicants for a sports wagering license, and they are Chesapeake Gaming LLC and Maryland Stadium Sub LLC. I'll be going through those packets individually and we'll vote on them as such. On November 18th, 2021, this commission determined for applicants for non-competitive sports wagering license, sections E1 through E6 of the Maryland Lottery and Gaming Control Commission's sports wagering facility application shall serve as a sports wagering license application for this commission, the Sports Wagering Application Review Commission, also known as SWORK. On August 10th, 2022, MLGCC found that the applicant, Chesapeake Gaming LLC, has established by clear and convincing evidence that it is qualified for and is not disqualified from a Class B2 sports wagering facility license. On August 15th, 2022, Chesapeake Gaming LLC submitted to this commission the requested portions of E1 through E6 of its applicant packet to MLGCC. This commission and staff has reviewed Chesapeake Gaming LLC's application in accordance with section 9(1)E 15F of the state government article. The Maryland Lottery and Gaming Control Agency also required the applicant to submit to MLGC an affidavit attesting to the minority and women-owned interests of the applicant. This affidavit is intended to provide additional information regarding the specific ownership of each sports wagering facility applicant. This affidavit was submitted with Chesapeake Gaming's application packet. This commission prepared a supplemental affidavit to MLGCC sports wagering facility application in order to determine both the number of owners of the applicant by gender, as well as the cumulative percentage of ownership. This supplemental affidavit was submitted with Chesapeake Gaming LLC application packet. Lastly, MLGC requested that each sports wagering facility licensed applicant submit a statement required under section 9(1)E 15I1 II of the state government article, noting whether this particular provision does or does not apply to the applicant. This statement also was submitted with Chesapeake Gaming's application packet. As a reminder, this commission must consider the public interest factors for the recently qualified applicant. Section 9(1)E 15O of the state government article prohibits the commission from awarding a sports wagering license under Title 9, Subtitle 1E of state government article unless the commission determines and declares that an applicant selected for award of a license is in the public interest and is consistent with the purpose of the sports wagering law found under Title 9, Subtitle 1E of the state government article. During the November 18th, sports wagering, the SPR meeting, this commission discussed 3 public interest factors, and they are: 1, enhance state fiscal resources, i.e. money for education; 2, economic development opportunities; and 3, regulating an unregulated sports wagering market. At this point, Mr. Chairman, you may wish to discuss these factors and then entertain a motion to declare that the award of a sports wagering facility license to Chesapeake Gaming LLC is in the public interest and consistent with the purpose of the sports wagering law found under Title IX, Subtitle 1E of the state government article.
Thank you, James. Are there any questions or comments or regarding the information that's just been shared with us? And if none, do I have a motion to approve the application?
Mr. Chairman, I'll make a motion to determine and declare that the award of the sports wagering facility license, Chesapeake Gaming LLC, is in the public interest and consistent with the purposes of Title IX, Subtitle 1E of the state government article.
Thank you, Mr. Mariner. Do I have a second?
Second.
Thank you. Any discussion, further discussion? All in favor? Aye.
Aye.
Any opposed? There are none. The application's approved unanimously.
Okay. We will now move to consider awarding a license to the recently qualified applicant. Mr. Chairman, at this time, you may wish to discuss and entertain a motion to award a sports wagering facility license to Chesapeake Gaming LLC, subject to the applicant entering into a memorandum of understanding required by the sports wagering law found under Section 9(1)(e)(15)(I)(2) of the state government article.
Any discussion? Do I have a motion?
Chairman, I would make a motion to award a sports wagering facility license to Chesapeake Gaming LLC, subject to the applicant entering the memorandum of understanding required under 9(1)(e)(15)(I)(2) of the state government article.
Thank you, Randy. Again, a second?
Second.
Thank you, Frank. All in favor? Aye.
Aye.
None opposed? All right, the motion carries.
Thank you, Mr. Chairman. Now we'll move to the Maryland Stadium Sub LLC's application. Again, on November 18, 2021, this commission determined that for applicants for non-competitive sports wagering licenses, Section 1E through, E1 through E6 of the Maryland Lottery and Gaming Control Commission sports wagering facility application shall serve as the sports wagering facility license application for this commission. The SWORC. On August 10, 2022, MLGC found that the applicant Maryland Stadium Sub LLC has established by clear and convincing evidence that it is qualified for and is not qualified from a Class A1 sports wagering facility license. On August 15, 2022, Maryland Stadium Sub LLC submitted to this commission requested portions, sections E1 through E6 of the applicant's MLGC sports wagering facility application. This commission has reviewed Maryland Stadium Sub LLC's application in accordance with Section 9(1)(e)(15)(f) of the state government article. The Maryland Lottery and Gaming Control Agency, MLGCA, also required the applicant to submit to MLGCC an affidavit attesting to the minority and women-owned interests of the applicant. This affidavit is intended to provide additional information regarding the specific ownership interests of each sports wagering facility applicant. This affidavit was submitted with Maryland Stadium Sub's application packet. This commission prepared a supplemental affidavit to MLGCC's sports wagering facility license application in order to determine both the number of owners of the applicant by gender as well as the cumulative percentage of ownership. This supplemental affidavit was submitted with Maryland Stadium Sub's application packet. Lastly, MLGCC requested that each sports wagering facility license applicant submit a statement required under section 91E15 I1 II of the state government article, noting whether this particular provision does or does not apply to the applicant. This statement was also submitted by Maryland Stadium Subs application packet. This commission now must consider the public interest factors for the recently qualified applicant. Section 91E15O of the state government article prohibits the commission from awarding a sports wagering license under Title IX, Subtitle 1E of the state government article, unless this commission determines and declares that the applicant selected for award of the license is in the public interest and is consistent with the purpose of the sports wagering law found under Title IX, Subtitle 1E of the state government article. During the November 18th SWORC meeting, this commission discussed three public interest factors, and they are enhanced state fiscal resources, i.e. money for education, 2, economic development opportunities, and 3, regulating an unregulated sports wagering market. At this point, Mr. Chairman, you may wish to discuss these factors and then entertain a motion to determine and declare that the award of a sports wagering facility license to Maryland Stadium Sub LLC is in the public interest and is consistent with the purpose of the sports wagering law found under Title IX, Subtitle 1E of the state government article.
Thank you, Mr. Butler. Any discussion for the benefit of our commissioners? This is the Commanders. This one's tough for me as a Ravens fan.
Mr. Chairman, this is Maryland Stadium Sub LLC.
Gotcha. Okay. Any discussion?
Mr. Chairman, I need to abstain.
Very good. Thank you, Laura. Duly noted.
Well, Mr. Chairman, I would like to make a motion to determine and declare that the award of a sports wagering facility license to Maryland Stadium Sub LLC is in the public interest and consistent with the purposes of Title IX, Subtitle 1E of the state government article.
Do I have a second?
Second.
Thanks, Brian. Any further discussion? Hearing none, do we have a motion to approve?
No, vote to approve.
Move.
Thank you.
Any nays? Hearing none, it's unanimous with Laura's abstention. Moving on, James.
Okay, we will now move to consider awarding a license to the recently qualified applicant. Mr. Chairman, at this time, you may wish to discuss and entertain a motion to award a sports wagering facility license to Maryland Stadium Sub LLC, subject to the applicant entering into a memorandum of understanding required by the sports wagering law found under section 91E15 I2 of the state government article.
Do we have such a motion?
Mr. Chairman, I'd like to make a motion to award a sports wagering facility license. You want to get discussion first before I make my motion?
Do we have any further discussion of this application?
Mr.
Hearing
Chairman,
none, I'd
I
like to make
abstain
a
from this
motion.
vote as well.
Thank you, Laura. Duly noted. Any other discussion?
So now I'd like to make a motion.
Thank you, Randy.
Award a sports wagering facility license to Maryland Stadium Sub LLC, subject to the applicant entering the memorandum of understanding required under 91E15 I2 of the state government article.
Thank you. Do we have a second?
Second.
All righty. Any further discussion? Hearing none, all in favor of approving the application?
Aye.
Aye.
Any opposed? Hearing none. With Laura's abstention, we have unanimous approval from those present.
Thank you, Mr. Chairman. That takes care of the two qualified applicants now that SWORC has awarded their licenses.
Thank
And we will, George and I will prepare the decision statement and forward that to the MLGCC.
Excellent. Thank you. All right, we're moving on to agenda item 9 on the pre-approved agenda. That's to discuss the timeline outlook for SWARK's award of competitive sports wagering license.
Mr. Chairman, if I could go back, we skipped number 8, discussion and vote on the proposed SWARK application.
Oh, did I mess up? I'm sorry.
Not a problem. There were
Do
just some there were some small tweaks to that application, and we just wanted to get it approved by the commission, if it's desired.
These were provided in advance of the meeting to the rest of the commissioners. These are generally minor modifications, as I recall. Anybody want to discuss them or comment? Do I have a motion to approve the proposed applications?
I'll move to approve the proposed SWARK application.
Do I have a second?
Second.
Thanks, Randy. Got any further discussion? Hearing none, all in favor of approving the application, say aye.
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 Any objections? Any opposed? It's approved unanimously.
And Mr. Chairman, if I can remind the commission, this is just the approval of the application. This is not the release of the application, because that is still subject to ALR's action, as well as the action of the industry analysis.
Thank you. Very good. All right, now we'll move on to item 9. And indeed, that picks up on what was just said, that as our commission understands, and the people listening to us, what lies ahead, we're reminded there's 2 items that have to be completed: the AELR approval and the receipt and legal review of the sports wagering industry analysis. And then once these are completed, our commission's intention is to promptly release the applications and open the process. So for everybody to understand, I've asked that the staff be prepared to explain to us what those next steps are leading to the award of competitive licenses. So with that, may I ask Jim Nielsen and Kim to guide us, please.
Thank you. Good morning, all. I've got some comments that I'm going to make. I would suggest that, Kim, if I say anything that I miss anything, please feel free to jump in.
Not a problem.
Okay. As the chair said, there are several steps and several things that have to happen as this process moves forward. Trying to lay it out in sequence for all of you. From the date that the SPR applications are officially issued to the world, applicants will have, we believe, between 45 and 60 days to complete their application and submit it to SPR. In a couple of minutes, we'll talk about what that time frame should actually be. If 45 to 60 days is the best number. As an aside, we've also made it a requirement that no later than 14 days after an applicant submits its application to SWARK, it must complete submitting its application into the licensing system for lottery and gaming to do the qualifications review. We have suggested this timeline or this window because we don't want any potential applicants to be taking an extremely long length of time to finish their gaming application, because that'll hold up the process. We can't qualify them unless that's done, and SWARK can't award a license until they have been qualified. Excuse me. Upon closing of the application window, that 45 to 60 day period, SWARK will begin its review of all the applications it receives, and the amount of time needed to review the applications will depend in large part upon the number of applications received. Right now, we're estimating that SWARK will need at least 45 days. That remains to be seen. It could be less, it could be more. And at the same time that SWARC is reviewing the SWARC applications, lottery and gaming staff will be conducting background investigations of these same applicants. The amount of time needed for these applications will again depend in large part on the number of applications received, as well as the complexity of the ownership and management structure, and whether the principals of the applicants have been licensed in other jurisdictions. Some applicants will be able to be reviewed fairly quickly. Those are the ones that are probably more seasoned and licensed in other jurisdictions, and others will take more time. Lottery and Gaming estimates that it will be able to complete its review of some of the more seasoned applicants within the same 45-day time period that SWARC is conducting its review of the applications. For SWARC to award a competitive sports wagering license, two things must happen for an applicant. The first is that SWARC must review the application and determine that the award of the sports wagering license to the applicant is in the public interest. And two, Lottery and Gaming must find the applicant qualified to hold a sports wagering license. Once these two determinations are made, then SWARC can award a license for sports wagering, whether it be mobile or a facility license. As a reminder, if there are two applicants within 1.5 miles of each other, then SWARC is going to have to review those applications and evaluate which of the two should be awarded a license. So that will be potentially some instances where more discussion is required before a license could be awarded. After SWARC's review of a sports wagering license, Lottery and Gaming must then, after SWARC's award of a sports wagering license, Lottery and Gaming must then approve the applicant's internal controls and policies, and the applicant must go through controlled demonstrations of its sports wagering operations before Lottery and Gaming can issue the license and the applicant can finally go live. Right now, we can't determine a specific timeline to complete these steps because, as we discussed before, there are many things that we don't know. We don't know when the SWARC application will actually be issued based upon the other gating factors. But staff believe that if the applications can be issued within the next week or two, it's possible that Marylanders could be able to bet on the Super Bowl on a mobile platform. And that's certainly, I think, everybody's hope. As I mentioned before, even after the applications are released, the timeline will be impacted by factors outside of our control, mainly the number of applications received and the complexity of the organizations applying. Having said all that, there are some policy decisions that SWARC must consider that affect the timeline. The first one, as we mentioned before, is the length of the application window. That is how long applicants will be given to complete and submit their application to SWARC after the applications are issued. We've assumed in these discussions a period of 45 to 60 days. Mr. Chairman, there have been conversations that it might be appropriate for a discussion today to determine what that time frame is, so that can be placed into the draft application and we'll be ready to go once the other gating factors are settled.
Thank you, Jim. So this was very important. What does the timeline look like, and who's got to do what in order for us to be able to both release our applications, turn the applications around, position the lottery commission to vet the internal controls and get the app going. Mainly, I'm speaking about the mobile. That's where we think the money is. So are there any comments or discussions? This notion of 45 to 60 days is a critical variable, and we're almost in September. So anybody got any thoughts on the topic?
We've opened up the portal to start the vetting on the lottery side. We've been talking about this for a year. In May, we had public outreach. The public is clamoring to get this thing going. And I would suggest a 45-day window would be a very workable solution.
Just as a point of information, we spoke to one of the quote smaller operators that plans on bidding, I guess, or submitting a competitive license. And while he didn't talk about 45 versus 60, because we thought that was inappropriate to raise that conversation before this meeting, he was very pleased, frankly, that the process had taken a little longer than initially anticipated, because it gave him, and his comment was, it probably has given other small operators the opportunity to do a whole bunch of things that they couldn't have gotten done if it was a more accelerated process. Finding a bank that would deal with a small operator was a big issue, as you know. The time allowed this particular operator to get a bank. 1, 2, it allowed them to hire some very experienced other people. So I'm not suggesting 45 is wrong. I simply wanted to make that comment because it was just 2 days ago that we spoke to that small operator who really called asking about the 5%, not about timing, but inadvertently was making some remarks about timing that would have suggested he was more in favor of a longer time.
Anyone else? I mean, I don't think it's reasonable to be shorter, but I think it's highly relevant that we've had this window of opportunity for Q&A, and I think we've all been pretty forthcoming about what's to be expected. And indeed, the heavy lifting is in the lottery regs that have been out there for a year. The stuff about getting your self able to have your background cleared and lining up the kind of dough that's needed to be financially viable. All those are the tough things. So the 45 days, sounds reasonable to me. So, but I want to make sure everybody has a chance to comment or weigh in. Because indeed it is August, and we need to call the ball on some of this stuff so that people can plan. So do we have a motion on this matter of the window?
I think
Application is released.
I like the 45 days. I like to keep it moving.
Do I have a second to Frank's motion?
If that was a motion, I'll second it.
Sounded like a motion to me.
Yes, it was.
Very good. Any further discussion on this? All right, all in favor? Aye.
Aye.
Anyone opposed? Motion for 45 days passes unanimously. Jim, further?
Yeah, the next item on the list is a question for the members, and that's, do the members think that 45 days is adequate for them to review the applications that come in? And obviously that's assuming we don't get 500. And it's not so much committing to a firm timeline as it's just a feeling, to have the resources available and to get through these applications in a approximately 45-day period.
I would like to ask that we have at least a week prior to any decisioning, because personally I have to check for conflicts, and that takes a little while.
Duly noted.
Yeah, I think that's fine. I mean, I was asked about this earlier about the time frame. It's hard to judge today. I think that's okay. I mean, it might be 45. It could extend some time to be, I don't know, maybe 60 on that end. But of course, I think we would endeavor to do it as quickly as we can and get information and review back to the commissioners to make their decision. I think, Jim, you're right. It'll depend upon the types of applications we receive. So it might be hard to pin us down on this one right now.
Yeah, I think effectively it means that the The applications have to be reviewed probably within a 35 day period and, presented to the full commission and board so that you guys can take a look at it and review it. Like, so,
It's aggressive.
It's aggressive, but I think it's worth going for.
Other commissioners, this is where the tire really hits the road for us, especially if we have applicants that are not past licensed Maryland gaming operators. And the heavy lifting, of course, will all be with the folks on the lottery commission staff, but we've got to be available. Any further? I don't know there's any action on our part. This is mostly a heads up as I see.
Exactly.
Yep, agreed.
Yeah, I don't think there's an action item required. I think it's just a discussion because what you're trying to do is put together to make a loose timeline for us.
Okay.
Again, time is of the essence. So I know that we are all anxious to get through this. We'll take whatever time is required.
Fine.
Sounds good.
Yeah.
Mr. Chair, I'll schedule special meetings as necessary. We have our monthly meetings already scheduled, but we will endeavor to schedule special meetings as needed.
Very good. I think that that's a very appropriate heads up. It's not so tough on us retirees, but I know others on this commission. This will be an imposition.
So let me ask a question. Will you be submitting all the applications, or will you be doing the pre-screening to see if, if the application's just not going to make it? We're not going to spend our time on it, are we?
We were anticipating a short period of about a week or so to do a pre-screen to see if there are any disqualifying matters. I guess an example would be if someone is applying for a facility license and they're in the shadow of M&T Stadium. So it's the initial review will just be the disqualifying factors. I don't think that we will initially look at the quality of a application in terms of the financing, things like that. I think that's going to be more the role of SWARC to make those policy calls.
Tim, you might want to explain how we've handled application reviews in the past in casino jurisdictions.
Sure, I'll take that. Basically what we do is we kind of lay them all out one next to the other, review them first to make sure they're compliant with the requirements of the application. If somebody doesn't answer 4 of the 5 questions on a particular page, obviously that's a deficient application. Number 2, we kind of look at them by category from there. Name, address, obviously check the box, check the box, check the box. When we get to the business plan, that's where the substantive work begins. Making sure they've got the right amount of equity, making sure that they've got all the items that are required for SWARC to review, and obviously Lottery will be reviewing their internal controls and stuff like that, which they'll also do when they do the live demonstrations. So it's category by category, and you try to make our analysis of those categories similar. So in other words, if it'll say the same words for each particular applicant, on each category. So equity, here's the dollar amount of their equity, here's their entire bankroll, here's how they're going to be doing risk management, et cetera. So we category by category, we'll bring that to the board and advise them, here's how they've answered each of these various categories. And we'll make decisions on that basis. We haven't determined what sort of writing we're going to produce, because to some extent that is going to be dependent on how many of these come in, how quickly we can get them reviewed, et cetera. We may end up doing a writing after the fact, but that's still to be determined.
It's very helpful.
Yeah, that was helpful.
Good.
All right, so I have one final thing to bring up, and this is another policy decision that SWARC needs to make, and it relates to how the licenses will be awarded by SWORC. Really, there's two choices here. The first is to say we are going to award all of the licenses on the same day. And the other alternative is to say, as the commission goes through the applications and finds individuals that they want to have a license, then as soon as Lottery and Gaming comes forward with a qualification for that application can be moved forward and approved. Our feeling is that if we wait for all of the applicants to be qualified, you're building in a pretty significant delay, because some of these applicants, as we said before, have never been through a licensing process. They really are going to struggle with getting all of their documentation submitted, and that will delay the review from Lottery and Gaming before we can qualify them. So our feeling is SWORC can review and identify the ones they like. Lottery and Gaming will make best efforts to get through the list of potential applicants, identify which ones have been qualified, and then once we qualify, SWORC can vote to award the license or not. So I think it makes it's more expedient, and it gets wagering running probably significantly sooner.
But even after the award, they can't go live until they've done controlled demonstration, correct?
That's correct.
Right. And that'll be varying speeds, I suspect, based on experience as well. I think the difficulty with this is, again, this is something that this body will have to decide. I'm not sure if there's an action that needs to be taken today to answer that question, only because I think a lot of it will depend upon the number of applications and also the quality and experience levels and so forth of those applications. But it is something that we will need to determine somewhat in the near future, of how to go forward and see if there's a possibility of issuing two hold and we issue them all at one time, or is it best to proceed on a rolling basis?
Just to underscore the point, if there's a lot of applications, or there's applications that are not complete, or something's wrong with them, the question is going to be, do you delay, blow past the Super Bowl potentially, end up waiting a longer period of time, or do you, as we think we would recommend at that point in time, start issuing, awards and going to the live demonstrations? I think the point Kim makes is that we might be able to defer having to make that decision until we see how many and what the quality is. But, just a
Something to be
suggestion.
debated amongst the group.
My only comment to that is, even if we wait and award all of them at the same day, they're not going to all go live on the same day, because there's a lot behind the scenes that has to be proven and tested and demonstrated. So, FYI.
I think that information is all very helpful. Does anybody want to raise any questions on that topic? I don't think we need to take action today, but again, this is an important heads up because we're going to have to call the ball ideally sooner rather than later on that aspect of what we're doing. But indeed, we're all on notice. That's going to be part of our job. All right, then. See if I can do this agenda thing right. I'm opening the floor to suggestion that we have another closed session. That's obligatory. I don't see a need at the moment, and I don't hear any such requests. So then moving on to item 11 on our agenda, the next meeting, we long ago scheduled Thursday, September 22nd at 9 a.m. As a regularly scheduled meeting. I imagine our working group will continue to convene ad hoc in between, and if anything comes up that calls for a special meeting, we've got a pretty good protocol in place.
And Mr. Chairman, and I can let the commissioners know that the SWORK regulations, the emergency regulations are currently going through the process and should be published in the August 26th edition of the Maryland Register. So that will be next Friday. That's when we should see the proposed regulations in the Maryland Register. And also that we plan to have a public meeting here at Montgomery Park at Maryland Lottery and Gaming Headquarters on September 9th at 11 o'clock. And that will be posted in the Maryland Register as well.
Thank you very much.
The purpose of that meeting is what, James?
The purpose of that meeting is to receive public comments on the regulations. Thank you.
And that's a golden opportunity for bringing people together. So any other business for today's meeting? I want to thank everybody for hanging in. This was a long one. Do I have a motion to adjourn?
So move.
Second?
Second.
Thanks, Laura. All in favor? Aye.
Aye.
Thanks everybody for a very productive session.